This just really demonstrates exactly what I was talking about, and that youth just want to be heard about their opinions, their thoughts, how it's going to impact them. And so, as I was saying, the trend used to be that we were not involving youth in their court hearings. The dockets were long. There were 25 cases on the judge's desk, and hearings were really short. And so it wasn't really a place for kids. And so now, really, with the advent of the Child and Family Services Improvement Act of 2006, what the feds did was they really showed us that the importance that they were going to place on involving youth in their court hearings. And so they passed this law, and it places the burden on the judge. So it's the court has to consult in an age-appropriate manner with the child about the permanency plan. Generally speaking, when you talk about the permanency plan, that happens at the permanency planning hearings. So this law really talks about what needs to happen during the permanency planning hearings. So the judge has to consult in an age-appropriate manner with the child about the permanency plan. So what does the term consult mean? And when we talk to the feds about it, HHS is the branch of the feds that sort of interprets what Congress says as it relates to child abuse and neglect. And so the feds say that they don't interpret the term consultation to require that the judge talk one-on-one to the child about the permanency plan, but what the judge has to do is find out what the opinion of the child is about the permanency plan. So it's not just what some person thinks is in the child's best interest, but that what the child actually thinks about the permanency plan. They obviously did not go as far as we would have hoped that they would have gone, and said the child has to be present, but that it really showed that HHS is placing a really high importance on the child's opinion and empowerment, and that the child needs to be involved in things that we decide about placement, that the judge decides about placement and permanency. The only case that we have found that is right on point is a New York case, and it's a family court case. And just the facts of the case are that there was a teenager, and he wanted to attend his court hearing. He was placed in a group home, and he wanted to attend his court hearing. The Child Welfare Agency tried to prevent him from attending the court hearing. Their argument to the judge was that he acted out, that anytime he would attend his court hearings, that afterwards he would act out. And so the judge held a hearing and said that that was not a good enough reason to prevent the child from coming to court. The judge actually did a fairly good job of going through all of the reasons that it's important to have youth attend their court hearings, and so acting out was not a good enough reason to prevent a child from being at their court hearings. And that and what the judge did was try to interpret the Child and Family Services Improvement Act, and really said that when the feds said that, they meant that the consultation requirement was that there has to be a two-way conversation between the judge and the child. So that's really the case that is on point. In your jump drive, there is this PowerPoint, as well as a couple articles that the ABA wrote on involving kids in their court hearings. And the group of folks that are up here on the PowerPoint really are, the who's who of child welfare and the courts. And each of those agencies talk about when it's important for youth to come to their court hearings, and all of them say at some point it is important for a child to be present in their court hearings, both for their own sake as well as information for the court. And actually, the Pew Commission really went even further and said that the courts need to adjust what they're doing and how they're operating so that the child feels more comfortable and that it is meaningful for the child to be present. And I actually tried, and I couldn't with this PowerPoint take off. Kansas changed their law. It's not 14 any longer, but the other ones are accurate. And I just put this up there just to give you a flavor of what other jurisdictions, what other states do with respect to allowing children to come to court. For example, in New Mexico, if a child is 14 or older and wants to come to court, if their attorney says that they want them to come to court, the only way that any party can object or can keep a child from attending a court hearing is if the judge finds there's a compelling reason to keep the child out of court. And then under the age of 14, if the judge finds it's in the child's best interest to come to court, then the child will come to court. And so those are just some of the, and there's actually, beyond this in Arizona, I helped them come up with a court rule, and there's not an age on it. And it actually says in their proposed court rule, it hasn't passed yet, but that all children shall come to court unless the child's attorney files a motion either in writing or in person, and then a good cause finding by the judge. So it's actually a standard of good cause to say why the child, to excuse a child from their court hearing. And good cause could be because the child doesn't want to come to court. That would be, that would sort of constitute good cause. And so they have actually gone to the point where they're going to require a judge to find good cause. The other interesting thing about that court rule is that the judge also has to ensure that the child's attorney has seen and has had contact with the child. So now at every hearing, their judges have to ask the attorney, when was the last time you saw your client? And I was talking to the judge who actually started this court rule and trying to push it through. And he was finding the first time he asked, every attorney in his courtroom said, I haven't seen my client in between the last hearing and now. And as he's been doing it over the course, as the weeks go on, that is starting to change. He's now finding that kids' attorneys are now seeing it because they know that they're going to be asked about it when they come to his courtroom. And so I think that court rule has done a lot, not just for having kids involved in court, but also for the amount of contact between the child's attorney and the child. And so when I talk to your judges in the morning tomorrow, I'm going to tell them about that rule, and hopefully that'll start happening. But what you're concerned about is in Nebraska. What does your statute say? And so notice of the court hearing is given by the court. So again, the burden is placed on the court to provide notice, as well as the right of these folks to participate in the court hearing. So burden is on the court to provide notice of the hearing, as well as the ability to be present at the court hearing. It's given to the person charged with care of such child, the child's parents or guardian, unless a TPR has a court. And then what we're here about, the foster child, if the child is 14 or over. So again, there is an age, it's 14 or over. And as I did in the last one, I want to get an idea, folks here. Is this happening? Are the courts giving notice to the child age 14 and over? Yes? Anyone in any jurisdiction not getting that? Okay, excellent, okay. Okay, I want to just spend just a couple minutes talking about why you would think it's important for youth to come to their court hearings. I've talked it's kind of easy for me to stand up here and talk about what my clients have said. I want to hear from you all about why you think it would be important for a child to come to their court hearing. Thoughts on that? Do you not think it's important for kids to come to their court hearings? Yes.
Well, overall, it's usually a good idea. But a lot of it is dependent on how old the child is, what the cognitive abilities of the child are, and then the type of hearing. I mean, if there's going to be some bad stuff that comes out, or some adult information that comes out about the parent or the parents, what they're doing or not doing, that might be detrimental to the child.
Right.
There's a question of whether they should be there. But overall, it's a good idea.
Okay. All right. And okay. Yes, sir. Go ahead.
I'm a therapist, and I work with kids that sometimes have to go to court, and I don't think it's age dependent. I think it's developmental dependent.
Okay.
Because some young kids, 7 and 8, want to go to court and they want to tell their story. Some 16-year-olds
don't want to go. Right.
The key is preparation. These kids know what's going to happen when they go to court.
Absolutely. Absolutely. Yeah. Okay. So thoughts on. Okay. So why do you think? I mean, you said overall it would be important for a child to come to court with a couple of criteria put into place, as did you. Why do you think it's important overall for kids to come?
First-hand experience on what's happening, so that it's just, they're there face-to-face rather than someone always telling. So much of what their life is about other people telling them what's happening.
Absolutely. So they get firsthand information. So they actually see what is happening. They understand, again, this is a court hearing that is talking about what's happening in their permanency plan with their placement, and they're actually hearing about it. Oftentimes we've heard from kids that they hear from their parents about things that the parents are doing or aren't doing. And then they come to court and they find out that might not always be true. So excellent point. Other ideas about why it's important for youth to come. Yep.
Just that the judge doesn't recognize them as a member, but as a person. As a CASA, I always encourage my volunteers, if the child does not come to court, that they give a picture to the judge, and that kind of gives the judge a snapshot of the child. If they're little, as they grow up, so they can see how they are maturing.
Absolutely, absolutely. So it really puts a face to the file, to the name. As I said, there are times that judges will have 25 cases on their docket, and to actually have a child present there really brings home that this case is about this child, that we're talking about the growth and the permanency of this child, especially if a child's been in care for 3 to 4, 5 years. The judge can see that child growing up while in foster care and really emphasizing the importance of permanency. Excellent point. Other thoughts? Yes?
I would just like to say I am an alumni of foster care and to the court system, and I agree with everything you guys are saying, and better yet, your comment about make sure that young people are prepared for court, because I think that was one of my biggest barriers was I showed up to court and nobody had really prepared me for what was happening, so I was scared to death to be there. And if these young people have a CASA or Guardian Ad Litem who's going to explain everything to them, I think it would be a much easier process.
Excellent point. Excellent point. And I appreciate you coming and sharing your ideas. Yes.
I think the other thing that we may need to consider is follow-up support after a child has come to court. I think very often we think that someone, the parents, the case manager, whoever, is going to be responsible for checking on that child after court happens.
Right. Doesn't always happen. Right. Absolutely. Absolutely. Okay. All right. Other thoughts? You didn't have. No. Okay. Other thoughts. Okay. All right. What I want to do, I think, is I want to jump a bit, not in the PowerPoint, which is good because I don't think any of you guys have it, is really talking about what the two of you, I think, were just talking about. And this is really how to ensure that the court process is meaningful for the child. And so I want to kind of talk about steps to do that. And I think that so in advance, so before the court hearing, what needs to happen? And again, our goal is to ensure that the child has a meaningful experience in court. So if you have decided that a particular child is going to come to court, and we'll actually talk about how to decide if a child is going to come to court, then so after you have decided that, before coming to court, what things have to take place?
I meet with the child and discuss, I go over the reports that are going in. So they see my GAL report beforehand, they see the caseworker's report beforehand. We discuss what I anticipate is going to happen and whether if there's going to be testimony or if it's just going to be a basic review and there won't be testimony, and then whether or not they want to talk. But I've been talking to
Okay, and your role is?
GAL.
Okay, so the Guardian Ad Litem's role, first to prepare the child, first is to see their client. They have to see their client in advance of that court hearing. Things that they have to do when they're going to prepare the child, you're absolutely right, is to talk about, first off, who's going to be there? Who's going to be at this court hearing? There are some states around the country that have programs for kids to come to court in advance. It is not during their courting, but to actually see the courtroom, to actually see where people are going to sit, to actually see that there's going to be a judge that's going to sit up there, and then actually have a discussion about why it's important that they're there. A lot of kids have talked about they don't understand why it's important to go to their court hearings. So having some sort of a educational environment for the child to learn why they should be in attendance at their court hearing should happen well before they come to their court hearing. Has anyone had that kind of experience? Has that been done in any counties where that sort of an organized way to do things? Yes.
We do it though for the criminal stuff, not so much for the review hearing.
Okay, but that can be translate. How does that happen?
We do it a couple different ways. Like, let's say the children's had a forensic interview, we'll bring them to the CAC and let them watch their interview with their therapist again, and then we also started doing like depositions up at our center and kind of preparing them, and then actually taking them to the court, and then we have like handouts and movies and notebooks and stuff like that just to explain everybody.
Absolutely. That is so key that they actually see the courtroom, but two, I think that you're right. A lot of jurisdictions have books on the process that are age appropriate for kids. How is the court hearing going to work? Who's going to be there? So excellent point. So the Guardian Ad Litem goes, sees the child, talks about why it's important for the child to come to court, who's going to be there, what clothes to wear to their court hearing. A lot of times, I've had clients come in and they're in short skirts and low tops, and to really talk about what is appropriate to wear, and that can be helpful. I mean, to us, we understand, you wear a suit when you go into court. But for kids, that doesn't come easily to them. So really having a discussion about that. Other things that the Guardian Ad Litem or the CASA should talk about in preparation. Other ideas? Talking about, yep. Mm-hmm.
Well, I would think that the child should know what they're going to talk to the judge about.
Yep, absolutely. Absolutely. So what is the purpose of the hearing? I mean, there are all different kinds of hearings. Is this a adjudication hearing where you're going to be talking about kind of the facts of the case? Is this a permanency hearing? Are you going to be talking about what could potentially be a permanency plan? Is this a placement hearing? Are you talking about a change in placement? So exactly what's going to be asked, what's going to be talked about, and what the child should be prepared to answer questions from the judge. And you can have a discussion. What does your client want if it's a placement change hearing, does your client want to change placements? Does your client want to stay in that placement? Why? Actually doing that kind of preparation about the kinds of hearings. We actually talked about in the previous workshop, having kind of an outline, doing an outline with your client about what kinds of things he or she wants to talk about, wants the judge to know. What things do you want to gain out of it? Excellent. Other things that the Guardian Ad Litem should be doing in preparation. Okay, what about a foster parent? What should a foster parent be doing in preparation for a child coming to court? Because it's really important. I'm not standing up here advocating a child being plopped down in the court hearings with no support structure. Oftentimes, the foster parent is the one the child really trusts, or the group home staff. What should we be requiring of the foster home, the foster parent, or the group home staff to be doing to prepare a child for coming to court?
It'd be nice if they transported.
Exactly. Transportation. Who's going to bring the child to court? That's one of the big reasons kids are kept out of their court hearings. It's because who's going to transport them to and from the court? So talking with either the group home staff or a foster parent about transportation. Other things that a foster parent can talk about to the child or just do in the preparation. Mm-hmm.
Help facilitate conversations with others who are going to, with the Guardian Ad Litem, for instance, or others who will be in the hearing.
Absolutely. So of course, the Guardian Ad Litem is going to come to the home to see the child, but to really help the child, to prepare the child to speak to the Guardian Ad Litem, to help the child speak to the case worker, help the child speak to anyone who's going to be involved in the court hearing. Excellent point. Anything else in preparation? How about school? Is school an issue with kids coming to court? And how should the foster parent handle the school issue? Thoughts on that? Mm-hmm.
In our jurisdiction, we work with our public school, and the superintendent of the public school has said if the child has to miss school for the hearing, it will be an excuse.
It will be an excuse. Excellent.
We try to
Excellent.
schedule the hearings at the end of the day.
Excellent. So that's important. So ensuring that the school be aware that the reason the child isn't present is because of the court hearing. That a lot of times we have gotten a lot of concerns that kids are not brought to court, and you ask why, and it's because of the school issue. It's because it's not an excused absence. Well, has anyone talked to the school about that? That should be one of the tasks of the foster parent or the group home staff, is to establish a relationship with the school so they understand that occasionally the child is not going to be present at school because of the court hearing. So transportation, school, ensuring that they're able to talk to the guardian ad litem, other roles of the foster parent. Yes?
Just being there to have a child share their feelings,
Mm-hmm.
maybe if it's traumatic, maybe make sure they get to talk to their therapist or whatever.
Absolutely. That,
Before and after.
right. So in advance, ensuring that if the child is in therapy, the therapist is aware that there's a court hearing coming up, and that the therapist can play a role in preparing the child. What does the child want? How does the child want to stay in the court hearing for the whole time? I don't know if you have any thoughts on that about the therapist role. Did you have any thoughts?
Basically what you're saying, in my experience, I just help them to really just to do the basic stuff, just be there, be polite, be honest, answer the questions, let them know that what they want may not be what they get, kind of prepare them in that way.
Absolutely. That's a excellent point at the end, is that there's going to be a lot of times what the child wants isn't exactly what the child is going to get. And we've talked with youth across the country about that, because that was a concern that judges brought up, saying, you know, I'm in this courtroom, the child, you know, who's 12 years old is saying, I want to go home to mom. Mom isn't in place. There's no way this child is going to go home to mom. I don't want the child present because I don't want the child to be upset about that. And so then they were excluding children because of that. And what we have found, and you can comment on this, is that the children want to have their input heard. They understand that even if the judge isn't going to do what they say, that they want to feel that the judge has heard them, that the judge has taken into account what they have to say. And as long as the judge explains, you know, I understand what you're talking about, what you want, but here's why I'm not going to do that right now, and to kind of talk about what can occur in order to achieve what the child wants. So excellent point. Okay, anything else that the foster parent would do to prepare the child? Okay, anything special the caseworker needs to be doing in order to prepare the child to come to court? Yes?
I worked with a caseworker we had a 10-year-old, and he's got a lot of energy. And we do have a judge who's very nice to let the child come up and sit and kind of be more of a friend, one-on-one talk. But what I liked with her was, because he would get up there and he'd just rant, or he wouldn't know.
Mm-hmm.
And we would have time to sit down with him before and write down 3 things.
Mm-hmm.
3 things that you want the judge to know.
Yep.
And the other thing that I remember too is him bringing a picture that was very important to him. So I think having him bring those things and some of the positive things that they're doing, or their report cards or whatever. But I always thought it was nice that she would go through and those are the 3 things we could discuss, because otherwise it would have gone on for a long time.
Absolutely. To really, again, to do some sort of an outline for the child. And the caseworker can be involved in coming up with that. Oftentimes the child has a closer relationship to the caseworker as opposed to the guardian ad litem. So kind of coming up with exactly what the child is going to talk about. Other things that the caseworker can do. Okay, now during the court hearing, so while we're in court, first of all, before we actually get into court, talking about how to really involve kids. A lot of times what we have said is that children are either involved in their court hearing totally or they're excluded. And so what we are encouraging is to become creative when it comes to how to include kids in their court. And so here are just some ideas about, instead of kind of taking sort of these extremes that kids are involved in their hearing the whole time or they aren't involved at all, that the child can have an opportunity to speak to the judge in chambers. Does that happen in anyone's jurisdiction? Anyone have any experience that if the child is concerned about talking in an open courtroom, if the child is concerned because there's a parent there the child does not want to see, or if there's a no contact order, talking to the child in chambers with the judge, happen in anyone's jurisdictions? Sure. Yes. Okay. And what is the process in your jurisdiction for asking for that? Is there anything that has to occur?
The juvenile, the child or youth has a meeting with the guardian ad litem, and the guardian ad litem presents them with the option of what kind of format they would like to talk to the judge. And in chambers is one of the formats. They can say, do they want the courtroom, if they want to go to the courtroom, do they want the courtroom, do they don't want the courtroom. So we kind of put it on the guardian ad
Excellent.
litem and the youth's shoulders to determine what the settings.
Excellent. And so then the judge needs to be informed of that in advance, and the child should absolutely guide that. Also the guardian ad litem, the therapist. How does the child actually talk to the judge, either in chambers or even coming into the courtroom for a portion of the hearing? A lot of times we just try and that we want to, again, either have the child present during the whole thing or not at all. How about having the child present for only a portion of the hearing. If there's going to be a portion of the hearing that we think could potentially harm the child, to hear information about, or if we're talking to the parent about what the parent has to be doing. To have the child present only during that portion of the hearing where the judge talks to the child about placement, about school, about things that the child, the 3 things the child wants to talk about. And then for another portion of the hearing, actually excusing the child from that portion of the hearing. And then another way that has been done it is to actually bring in a child's hearsay statements into court, either a letter that the child can write to the judge. Obviously, it has to be given to all parties. But those are just some of the options before you get into the courtroom that you should take into account, so that we can, because the goal, again, always the goal of including kids in their court hearings is to do the things that we talked about: empowerment, ensuring that they have all of the appropriate information. So how to achieve that goal needs to always be in our mind. And so here are some ways to do that. Are there other thoughts about different ways to include kids other than what we have talked about? Other ways to actually include them in the court hearing?
I think my colleague over here mentioned as far as requesting that the courtroom is as comfortable as possible for the child. So if there are people, strangers who don't necessarily need to be a part of the hearing, are asked to leave the courtroom to enforce the hearing, but anything that you can do to create a sense of comfort within the courtroom, I think is helpful.
Absolutely, absolutely. So, I mean, I understand that in your state you have open courtrooms, so a lot of people can be present. If your client expresses, or if your child expresses that they're not comfortable speaking with all of those people, ask the judge to clear the courtroom. Ask the judge to ask everyone who isn't involved in the case to leave. If that isn't going to work, ask to approach the bench so that it is just the child welfare agency, the Guardian Ad Litem, and the child and the parents' attorney all present around the bench, or asking to see the judge in chambers. Again, being creative when it comes to how to involve the child so they are empowered and get as much information. Sure, go ahead.
Question?
Yes.
Does giving the deposition preclude the need to be in court for a hearing?
Okay, so the child?
The child participates in the deposition.
I mean, that's one option. I mean, I think it's still important because the child, to gain information about other things that are said. For example, the judge talking to the parent about the things that the parent has to be doing. The caseworker talking about things that the child has to be doing. Those things that information is not always gained if you just depose a child. Also, if the child wants to ask questions of the judge about why a particular ruling is being made. I think, but that is one way to sort of get the information from the child that the court would need would be to depose a child. But I would caution against using that exclusively because of what the child gains from actually being present. But that's another good option. Sure, yep.
I'd like to say the Foster Youth Council is working on a form similar to the form that I think I developed for foster parents, where if a young person was uncomfortable presenting in the hearing, where in a comfortable setting with their caseworker, with their CASA at home, they can fill out this form and write down their thoughts and their questions. And I don't know what is going to be on there yet, but this is something that they can do and then present to the judge and to the team, where their voice is being heard.
Mm-hmm.
Whereas, they can sit there during the hearing, but do not have to talk.
Right.
They don't want to.
Absolutely.
That would really make me nervous.
Absolutely. And we actually talked about it in the other workshop, that exact thing. Oftentimes I will have clients who will say, I want to talk to the judge, I want to say this, I want to say that. and they go into the court hearing and it's like, you know, I don't want to say anything, which is understandable. And so it's really important. I think that's going to be an excellent form for the child to be able to sort of articulate things that they want to say. And then if they still want to talk, giving the child the option to talk. But if not, then the guardian ad litem has that form and can give it to the judge, or the guardian ad litem can just say the things that the child would want. Yeah.
My question would be, when you're talking about those statements, because sometimes they're really appropriate if the child's in treatment, you know, in a area far from where the hearing's going to be, they don't necessarily want to be disrupted and transported. But when you say present the child's hearsay statements to court, and you said, well, for all the parties to see, part of this form you're talking about, is there an opportunity for that to be just a communication with the court? Sometimes
Right.
they want everyone to know that they would like their foster parent.
Well, okay.
Where maybe it can't just go to the judge. Or one of there was a conversation about it.
Right. Okay. Thoughts on that? Thoughts on it only going to the judge?
If the child wants it.
Right. Let's say that the child has said, you know, I want to talk to the judge. I mean, it could even be just talking. Hey, the child says, I only want to talk to the judge. I don't want anyone else present. Or I want to write a letter to the judge, and I don't want anyone else to see it. Thoughts on that? How's that going to go over? Yes.
Well, I think it's important to let the child know that you can make that request, but there's a possibility that it's not going to remain for information that only the judge has, and that there's due process rights that different people have due process. Explain that as best you can.
Right.
But let the child know that you can make that request, but it may not be honored.
Absolutely. So I think it's important, though, for the child to absolutely know that, generally speaking, a judge cannot talk to a party ex parte, which just means without the other attorneys present. So if a child just wants to talk to the judge in private, you would have to get consent of the other parties, or tape it, or in somehow sort of preserve the due process rights of all of the parties. And then if the child does indeed want to write to the judge, that there is going to be the possibility, and it's a pretty likely possibility, the judge is going to have to share that information with the other parties. Now, foster parents, I'm trying to think, I don't recall in your statutes, most states, foster parents are not parties. That's true here, right? So it wouldn't go to foster parents, but it would go, I mean, if parents are still involved, it is going to go to parents, it is going to go to the child welfare agency. So important to inform the child of that. All right, other thoughts about what happens sort of right before going into court. Okay, so in court, how are we going to address people's roles while in court? Where should the child sit? Who should the child sit with? Should there be a support person present? All of these things need to be talked about in advance to ensure that the child, again, is a meaningful court hearing for the child. Now when, I guess I didn't ask this to start with, are kids coming to court in your jurisdiction? Some are, some aren't. Yes? And yes? Okay. When they are coming to court, is the judge engaging them? Is there a dialogue between the child and the judge? And how is that working? Is it an open court? Is it in chamber? How's that work? I see you.
It's in open court, and I think it's going really well.
Okay. Other thoughts about, yes.
The judge addresses the child, talks to him, asks him about school. I think that kind of makes him more comfortable and not so intimidated by him.
Absolutely.
When we get going a little bit more.
Right. I think that's key, that the judge, and again, I'm going to be talking to the judges in the morning about sort of what the best way is, but really to, at the outset of the hearing, introducing yourself to the child, ensuring the child is comfortable talking about school, talking about things that have, so to ensure the child is comfortable. Sure, go ahead.
I was going to add one other thing. He does tell them that they are the most important thing in
Excellent, excellent. Okay, great. So other things that we think have to happen while the child is present in court. All right, I think okay, now almost equally as important is what happens afterwards. What happens after the court hearing? As a guardian ad litem, we'll have, 5 cases, and, they turn over quickly. We go in and we have a court hearing, and then the child leaves. What needs to happen is the guardian ad litem must take an opportunity to see the child right after the court hearing. Has to see the child to talk about what happened during that court hearing. It doesn't have to be long, but needs to talk about what did the judge rule, what's going to happen in preparation for the next court hearing, what the parents have to be doing, any kind of details that are appropriate for the child to hear. The guardian ad litem and even the caseworker or the foster parent needs to be talking to the child about what has happened during that court hearing. And then, if the child is in counseling or in therapy, and the guardian ad litem feels that the child needs to process it more, the guardian ad litem or the foster parent must contact the therapist or the counselor to say, this is what happened during the court hearing. Can we have an appointment soon to get the child in to really process what occurred during that court hearing. And then even following a week or 2 down the road, having the guardian ad litem contact the child. Are there any follow-up questions? The foster parent should be ensuring that if the child does have any questions, the child gets on the phone and talks to the guardian ad litem about those questions. Again, the only way to make a meaningful experience for the child is to ensure that they're prepared, they're properly supported while in the court hearing, and then after the court hearing, they're appropriately debriefed. Any other thoughts kind of about that process, sort of about the debriefing? Are we finding that those things are happening? That the preparation is occurring, the support during, the debriefing afterwards? Any places where that isn't occurring, and what kind of impact are we seeing? Go ahead.
Well, kids aren't there, but occasionally if a kid happens to be there, I saw, this was the first hearing, and the judge recognized that the child was there somehow, and it was a 11-year-old girl, and he asked her if she had anything to say. The courtroom was full.
Oh, wow. Okay.
She's not going to say anything.
Right.
I mean, she wasn't prepped, but we in our court haven't been having kids there, so the court's not.
So this is all new, right?
So
okay.
we need to work on that.
Okay, right. And policies have to be put into place. Both, I was going through the guardian ad litem policy in terms of how to prepare, and so we really have to have policies. Even for foster parents, they have to be trained about what's going to happen during a court hearing. Yes.
When we did the foster youth interviews for the video we showed, most of the kids said there was no contact when they left. That the guardian ad litem either didn't talk to them or didn't talk to them about anything substantive. It was just kind of a see you later.
Okay. Okay. Right. And that's the thing. And that's what we're seeing across the country. I mean, it isn't just here. It's that kids are just being expected. We have this new rule, and then kids are just being expected to have a meaningful hearing without sort of this support going on. And as you pointed out in the back, the key really is preparation, and I would say almost equally as important is what happens afterwards. Yes, sure.
Yeah, and I really think foster parents should, they should transport them. They should also attend the court hearings right alongside them, because they're going to be the ones that are taking them home, kind of debriefing them, and they're going to be putting up with them. I mean, really, they're
Yes.
going to be the ones that are
At 2 o'clock in the morning when the kid gets up, right?
And so it's good for them to be informed on what's happening.
Absolutely. So having some sort of, during foster parent training, really understanding about the court process and how they have to be involved in this court process and what role they're going to play, critical role in that preparation and debrief of the child in the court hearing. I saw a hand up here. Yes.
If a child is in the home of a relative after the hearing, I think fairly often what might be necessary is the Guardian Ad Litem may have 5-10 minutes. But is there a plan in place that the case manager or someone else has put in place so that there is some access to a support person for both of them, frankly, after the hearing? Because often, you know, things sort of sink in afterwards, and they may not be in therapy. They may not have a counselor to go to.
Right.
They may be hiding this information from the school. So they really need a plan in place. Who can these people go to? For
Right,
support?
right. And even I wouldn't even put the burden on the people to go to, that there's a plan in place. So 2 weeks after the hearing, the caseworker and or the Guardian Ad Litem needs to be, as a routine, contacting the whatever placement, if it's a relative, foster home, group home, to be processing, saying, you know, it's been 2 weeks, let's go over what happened at the hearing. Do you have any questions? Do you have any? So the burden is not always placed on the home and the child to make that contact, but that there be some sort of a checklist that the caseworker is doing after the hearing. That's an excellent point. Excellent point. Other things, other examples. Okay, I want to real quickly just talk. I sort of skipped over sort of concerns that folks have because I talked about it in the previous workshop, but I just want to make sure that I sort of validate people's concerns about having youth in court hearings. We kind of assumed, because we were doing sort of a nuts and bolts kind of thing, that the child was going to come to their court hearing. So I want to back up and just kind of get some concerns from people. We talked about why it's important to have kids in court, and I want to get an idea of what folks think. What are your concerns about having kids in their court hearings? Any concerns?
Misunderstanding.
I'm sorry?
Misunderstanding.
What, the child?
The process. Yeah, the child misunderstanding the process, what's being said.
Absolutely. So a child going into the courtroom not properly prepared and not understanding what is going on, and then not being talked about it afterwards. Excellent point. And I think a couple of the ways to sort of address that kind of the answer to that isn't to exclude the child from the court process, is to really, as we've talked about, preparation, and then afterwards having a discussion about what happened during the court hearing. Other ideas about how to address that, the lack of understanding on the part of the child. Okay. Other concerns that folks have, other concerns about what folks have, other concerns that folks have about bringing youth to their court hearings. Sure.
Well, the things that it might take them away from, whether it's school or extracurricular activities.
That is a big concern. School. I mean, our kids on average are moved 4 times while they're in care, and each time, generally speaking, they change schools. And so, what, for a court hearing to take the kid out of school again? Thoughts on that? Is that a concern that folks have? How are we addressing that, the school issue? I think you had said that you try and have your court hearings after school hours. So if they're school-age children and a child has expressed that they want to come to court, that trying to hold those hearings after school hours and requesting that time frame for a hearing. A lot of jurisdictions still have cattle calls, so at 8 o'clock in the morning and at 1 o'clock in the afternoon, everyone has to be there, and you've got 20 hearings on the docket. That absolutely has to change. There needs to be either block hearings where you have 5 hearings in a span of time, or actually having certain hearings so that kids, even if it could be early in the morning, coming in at 8:30 and having the hearing, and then going to school for their afternoon. So trying to address, I see you with your head shaking.
We have scheduled hearings, but this is juvenile court, and you might have 10 o'clock, and you get there and they haven't finished the 8:30.
The 8:30 hearing, right, absolutely. And, you know, so one of the ways to attempt to cut down on that is to have sort of time certain hearings, and also to ensure that you have talked to the school about, one, that it's an excused absence, and are there any, is there any homework or schoolwork that the child can be doing while there? And then when the judge picks the court date, ensuring that court date is not during a time when a child has standardized exams, when they have any kinds of, so instead of just sort of talking about the attorneys and the attorneys' schedule, taking into account the child also, and ensuring that we have accommodated the child's schedule. I think I just heard clapping. Is that okay? I have 1 minute. Okay, so just anything else that's sort of burning about concerns that you have about involving kids that we can try and address? I mean, it seems like things are going along okay. I think you said the kids are not coming to your court hearings. How come? Is it on behalf of the Guardian Ad Litem, or because of the judges, or?
The judge, but our team has identified that
that's an issue and starting to work on it. Okay, great. So other things, any other burning issues? Okay, we didn't get to, yeah, okay. So this is my contact information. Again, all of that, the whole PowerPoint, which has a lot of good information about sort of from the child's perspective. As I said, as we've traveled around the country, we have talked to kids about attendance in their court hearings, things that they want, things that they don't want. It's all in the PowerPoint, so that's all in the stuff that you have. But any questions that you have, that's my contact information. So thank you all very much for your participation.